Morning, sir.
Good morning.
Hi, is your last name Wilson?
Yes,
Okay, thank you.
no problem.
Ma'am, was that enough time or? Okay, thank you. Good morning, Mr. Coopers. How are you?
Good. Good morning.
I hope I said your name properly. Mr. Wilson is here. Do you need a breakout room with him?
Yeah, if I could have a quick moment to speak with him, I'd appreciate that.
Okay, sure. Hold on one second.
Good morning. Today is Tuesday, January 3rd, 2023. This is courtroom number one. I am Judge Martin. Today's docket is landlord tenant only. I'm sorry, that's not true. Landlord tenant and civil cases. If you do not have a landlord tenant or a civil matter, you may be in the wrong courtroom. If you're not sure, please send a chat message to the staff and they'll help you get where you need to be. When Ms. Bell stops driving, I'll call the case and we'll get going.
Okay,
Hello.
Yes, ma'am, are you driving?
Yes.
When you stop, I'll call your case.
Okay. Let's pull over. I'm pulling over.
This is 224779 GC Regency Park Apartments versus Bale. May I have your appearances, please?
yes, Dana Combest for Robert Warner for Regency Park Apartments, the plaintiff,
Your P number, ma'am?
42335.
Thank you. Ms. Bale, state your name for the record.
Adore Maya Bell.
Today, thank you. Today is the day and time set for the first pretrial on this matter. The parties have had an opportunity to speak. How are we proceeding this morning?
Your Honor, we're gonna try and work out a payment plan. But we also have a motion for summary disposition that's been filed. There's no notice of hearing on it yet, but if we need to, we'll go forward with that if we can't resolve it short of that.
When was it filed?
It was filed, I think, about a week ago.
Oh, no, here's my note. It was filed on December 8th, 2022. And civil staff has it noticed for hearing this morning. If you're ready to proceed, or if you want the motion heard on a later date, you let me know.
No, we can do it today.
Ms. Bell, did you receive a plaintiff's motion for summary disposition? It would have been the second week of December. December 8th is when the court received it. Attached to it would have been a copy of your lease,
Yes.
your security deposit refund notice.
No.
You didn't receive a mailing from the defendant, from the plaintiff within the last month?
No, I received something from the court within the last month saying that I have a court hearing today.
You didn't
Yes,
receive a big pack of information from the plaintiff with a copy of your lease attached to it?
Oh, yes, I'm sorry. Yes, I did.
And something explaining the damages they were seeking.
Yes,
Did you file a written response to it?
yes.
Ms. Combest, please proceed with your motion.
Yes, we have no response. All we have is the answer to the complaint. All right, so this motion for summary disposition is filed pursuant to MCR 2.116 C9 and C10, essentially stating that there is no valid defense and no issue, material issue of triable fact. So we are entitled to judgment as a matter of law. There was previously a landlord tenant possession with money judgment in this case from 2017. There's been interest accruing since that time, and damages from the property as well as rental that went unpaid. So our claim is for $3,266.80 plus allowable costs and fees. Do you want me to proceed further?
No, ma'am. Ms. Bell, your response to plaintiff's motion.
I have no response.
Thank you. Inasmuch as the defendant has no oral response to the motion, has not submitted a written response to the motion that was duly filed with this court and notice for hearing this morning, plaintiff's motion for summary disposition will be granted. Plaintiff's office will submit a judgment to the court that has damages in the amount of $3,266.80. There was a $75 filing fee. Ma'am, the court received $31.63 for the service fee, and then $20 motion fee, $75 attorney fee. You can email that over to the civil department. They'll send it up for signature. Anything else on behalf of the plaintiff?
Do you have an email address for me?
It's civil, they'll put it in the chat for you. It's
Oh,
civil at
thanks.
34th District Court-mi.org.
Okay.
Anything else, Ms. Bell?
Yes, so am I not able to be on a payment plan?
Yes, you are. That's something you can discuss with the plaintiff's office, and if you're unable to come to an agreement on the payment plan, you can submit a request to the court, a motion for a payment plan.
Okay, so I will have to reach out to the attorney, Robert Warner, myself, and come up with a payment plan with his office or his team.
Yes.
Okay,
Anything else, Ms. Bell?
no,
Have a good day.
Thank you,
thank
Your
you.
Honor.
Thank you.
All right, bye.
This is 224452 GC. This is Community Financial versus Corey Wilson. May I have your appearance, please?
Good morning, Your Honor. Matthew Kuipers on behalf of the plaintiff, P71348.
Mr. Wilson, state your name for the record, sir.
Corey Wilson.
Thank you. Today is the day and time set for the first pretrial in this matter. Have the parties had an opportunity to speak?
We have, Your Honor, we've actually come to an agreement whereby we're going to be mailing Mr. Wilson a consent judgment for the full balance of $1,328.36 plus costs of $134.60. Statutory attorney fee of $75 for a total of $1,537.36. And we've entered into a payment plan on that whereby the defendant agrees to pay $50 per month starting January 16th.
Mr. Wilson, that's the agreement that you've reached with the plaintiff's office,
Yes, Your Honor.
and you'll be signing a consent judgment with those terms?
Yes, Your Honor.
What this court will do is make notes in the file that a consent judgment is forthcoming, but we'll also adjourn the pretrial to February 7th, 2023 at 9 a.m. back on Zoom with me. If you get the consent judgment signed and filed with the court before that date, Mr. Wilson, the court will take that February date off the calendar, okay?
Okay.
Anything else on behalf of the plaintiff?
No, Your Honor, what time was that February 27th date? At
9 o'clock.
9 o'clock. Okay, thank you.
Anything else in this matter, Mr. Wilson?
No, Your Honor.
Thank you. That concludes this matter. Mr. Wilson, you had another case with Stuart Collis office, the Davenport University matter. I've not seen Mr. Collis yet this morning. My policy, Mr. Wilson, is 15 minutes after the scheduled start time. So I'll pass your other matter momentarily. If Mr. Collis is here by 9:15, I'll call the case and get you on your way. When he appears, if he appears timely, we'll get you into a breakout room to discuss that case with him, okay?
Okay.
Thank you.
No problem.
Is there something else ready, Mary Ann?
No, ma'am.
Thank you.
Judge, I do have another matter at 9:15 with Michael Evans, who I believe
Have you
is
spoken to
here.
Mr. Evans?
No, I've not. If I could go into a breakout room with him, I'd appreciate that.
Absolutely. Marianne will get you moved into a breakout room with Mr. Evans.
Thank you.
You're welcome. Mr. Mueller, did you like to speak to Ms. Phillip this morning?
Actually, we've resolved the matter, Your Honor. I just
Oh,
couldn't get it
then
off the
let's leave
docket.
with that. Give me one second, sir. It's
Certainly.
magic to my ears. 225479 GC. This is International Extrusions versus Emerging Advanced Products. May I have your appearances, please?
John Mueller on behalf of the plaintiff.
Laura Phillip on behalf of defendant Emerging Advanced Products.
Thank you. Today was the day and time set for the first pretrial in this matter. The resolution of this case is, sir?
I'm sorry, Judge, I didn't catch that. My speaker isn't that great today.
That's okay. You came in and said that you have resolved this matter with Ms. Phillip. My question to you is, what is the resolution?
Oh, the defendant is to pay $3,750, and we just made that agreement late last week. We didn't have time. I called the court. They wanted a writing, and I couldn't get it in time, so we zoomed in to tell you that it's settled. We'll
No
be
worries.
dismissing.
The $3,750 will be paid by when, sir?
It was my understanding that I think they've already sent it.
Ms. Phillip?
I'm not sure if the payment has been made yet or if it's on its way. I know my client was out for the holiday, but we'll be following up. It should be coming promptly.
Well, yeah, I guess we don't have a date, Judge. I apologize. Like I say, we were just putting this together.
No worries. The holiday, I think, tends to throw people off. What we'll do is adjourn the pretrial to February 7th, 2023, back on Zoom, back with me.
Perfect.
If you can confirm the payment's been made by Ms. Phillips' client, you want to send the stipulated dismissal over. Otherwise,
Yes,
I'll see you here
excellent.
on February 7th.
Thank you very much. Have a great day.
Thank you, Your Honor.
Happy
Anything
New
else
Year.
on behalf of the plaintiff?
Nothing, Your Honor. Happy New Year.
Anything else on behalf of the defendant?
No, Your Honor.
Thank you. Happy New Year to you too. Have a good day.
Thank you.
Mr. May and Ms. Shell, do you need to speak?
Good morning, Your Honor. Erica Shell, P80106 on behalf of Arnold Boyd.
No, ma'am, I wasn't calling the case yet. My question was, did you need to speak to each other?
Oh, no, we're on the same side, Your Honor.
Oh, thank you. All I saw was Boyd and thought, ah. Are we ready on the Evans matter?
No, Your Honor, I wasn't actually able to speak with Mr. Evans. He's having connection issues for audio. I'm not sure if there's a phone number he can dial in or,
He's back. He just doesn't have his audio connected.
correct.
Let's figure out. He has a headset on, which suggests that audio is. Marianne, have you tried?
No, I have not.
Okay.
Looks like he's trying to connect.
Oh, okay. Now I remember this. Marianne, I reviewed the files last Wednesday and it feels like a million years ago. This is 222388 GC Davenport University versus Corey Wilson. Mr. Wilson, are you still with me?
Yes, Your Honor, I'm still here.
Today was the day and time set for the first pretrial in this matter. The case is scheduled at 9 o'clock. It's now 9:16 by the court's clock. Davenport University. No one is responding. The attorney for the plaintiff has not checked in, Mr. Wilson. Based on the plaintiff's failure to appear this morning, this case will be dismissed. Mr. Wilson, please know that this dismissal is without prejudice. It does not mean that the plaintiff will not refile the case, okay?
Okay.
Anything else, sir?
No, this is all.
Have a good day. Thank you.
You too. Thank you, Your Honor.
Mr. Evans?
Yes, I'm here. I had trouble when,
The plaintiff's, no worries, you're good now. You'll see an invitation to go into a breakout room with the plaintiff's attorney to discuss this case, okay?
okay,
Thank you.
thank you. All right, can you hear me now?
I'm able to hear you, sir, but you'll see an invitation to go into a breakout room and discuss the case with the attorney.
Okay, thank you. Thank you, Your Honor.
Thank you. Oh, Marianne.
Okay. Hello.
Ms. Lucas?
Yes, I'm trying to get in. I'm sorry.
No, you're fine. You're
Oh,
fine.
there we
Ma'am,
go.
do you have an attorney joining you this morning?
No, we do not.
Are you a licensed attorney, ma'am?
No, I am not.
Then ma'am, you cannot represent the incorporated entity of Lucas and Sons Enterprise. You need an attorney to represent you in this matter.
We have the two owners right here, myself, Marilyn Lucas, and my husband, Frank Lucas.
Let's go.
I understand that, ma'am, but you cannot represent an incorporated entity in the state of Michigan unless you are a licensed attorney in a general civil matter. If this were a small claims matter, it'd be a different case, but a general civil case requires you to be represented by an attorney.
I'm not hiring an attorney.
What's this? How do it? Nana? Oh, join.
Sir, I appreciate and respect that, but I cannot allow you to represent an entity. It's called the unauthorized practice of law when someone who is not a licensed attorney in the state of Michigan undertakes representation of another.
Well, fine.
This is 223224 GC. This is Lucas and Sons Enterprises versus Arnold Boyd Jr. May I have your appearances, please?
Good morning, Your Honor. Erica Shell, P 80106, on behalf of the defendant Arnold Boyd.
AP 85587 on behalf of defendant Arnold Boyd.
Mr. and Mrs. Lucas, I will offer you again to adjourn this matter
I can't hear
to
you.
retain counsel. Is that something you'd like to do?
Frank, I can't hear you loud enough. I'm sorry. Could you say that again?
I said I am offering you the opportunity to adjourn this matter one time to retain counsel to represent the Lucas and Sons Enterprises as an entity. How would you like to proceed this morning?
Well,
They will adjourn at one time to get counsel.
you have a case, do you have a case pending? Well, then I'll just go on,
We can't combine them.
huh?
They won't let us combine them. I tried that.
Well, you got it. The man owes you the money and you owe me the money.
Yeah.
So you don't have,
Since she filed that thing.
Michelle,
After him.
Yes, Your Honor.
how would you like to proceed this morning, ma'am?
Your Honor, I would like to proceed with the motion as scheduled if they're not planning to retain an attorney. And I would also note for the court that there appears to be someone else speaking with them in the other room. I'm not sure if that's an attorney or not, but that person's not identified to the court.
That person is not an attorney. That is Mr. Thomas Maycock.
So my question again, on behalf of Lucas and Sons, would you like an adjournment to retain an attorney? The adjourn date would be February 7th.
no, I'm not gonna hire no attorney.
Also, we will be out of town February 7th, so that wouldn't work either.
If you're not going to retain an attorney, the issue of you being unavailable on the 7th appears moot. Ms. Shell, your motion.
Good morning, Your Honor. This is the date and time set for a hearing on Arnold Boyd's motion under 2.116 C7 and C8 to dismiss the complaint filed. As the court has noted, it was filed by an individual on behalf of a corporate entity. But the key issue with this case is that it alleges a contract for sale of goods over $1,000. The amount sought in this case exceeds $1,000. And based on the allegations in the complaint relates to the delivery of gravel, which is a good. There is no written contract described with Mr. Boyd because there wasn't one. The complaint describes that, in fact, Lucas and Sons was contracted by a third party to deliver product at a property owned by a corporate entity that's associated with Mr. Boyd. And so a claim personally against Mr. Boyd is not supported by the allegations in the complaint, even accepted as true. Where the allegations in the complaint fail to state a claim on which relief can be granted, dismissal is proper under 2.116 C8. Dismissal is also proper under 2.116 C7 under the statute of frauds because a contract for sale of goods exceeding $1,000 must be evidenced under Michigan law by a writing signed by the party to be charged, and that would be Mr. Boyd in this case. Under either basis, dismissal of the complaint with prejudice is warranted. I will note that I did not receive any response to the complaint unless the court has received something on file that was not served. I believe there to be no response.
No response to the motion. You said to the complaint.
Right, unless Your Honor has any questions for me, I believe that establishes a basis.
The court has no questions. The court did have the opportunity to review the motion in its entirety and will grant defendant's motion. Ms. Shell, if you would be so kind as to present an order to the court granting your motion. Anything else? Ms.
Would you
Shell
like
or
it-
Mr. May?
Would you like it by email, Your Honor?
Whichever is best for you, email or snail mail. The court has
Okay.
no preference.
Thank you, Your Honor.
Thank you. That concludes
Honor.
this matter. Have a good day.
You too.
Are we ready with the Evans matter?
We just dismissed.
Yes, we are, Your Honor.
This is 224766 GC. This is Midland Credit Management versus Michael C. Evans. May I have your appearances, please?
Good morning, Your Honor. Matthew Kuipers on behalf of plaintiff P71348.
Good morning, Your Honor. Michael Evans, present.
Good morning. Today is the day and time set for the first pretrial in this matter. How are we proceeding?
Your Honor, I spoke with the defendant. He believes this debt may have been paid through some consolidation program. So at this point, we're just requesting 60 days for discovery to exchange information and see if we can work something out.
Is that accurate, Mr. Evans?
That's correct.
"60 days of discovery will commence today. We'll adjourn the pretrial to March the 7th, 2023 at 9 a.m. back in courtroom number 1, back on Zoom. If you're able to reach some agreement before that time, Mr. Evans, the attorney knows how to send you the paperwork to let the court know that it's been resolved and you will not have to appear in March. Anything else on behalf of the plaintiff?
No, Your Honor. Thank you.
Anything else, Mr. Evans?
No, Your Honor. Thank you.
Thank you. Good luck. Have a good day.
You as
You
well.
also.
Thank you. This is 126440 GC. This is One Main Financial versus Sherry Taylor. May I have your appearances, please?
Christopher McNeely on behalf of the plaintiff.
Ms. Taylor, state your name for the record, please.
Yes, my name is Sherry.
Thank you. Today is the day and time set for hearing on the plaintiff's motion to set aside the payment plan. Mr. McNeely, have you and Ms. Taylor had an opportunity to speak?
We have, Judge, and the basic proposition that we've discussed is that we will voluntarily go back to making payments, but we would like the order with the court to be lifted so that if the payments failed to be made, that we'd still be able to proceed with periodic garnishments against her wages.
Ms. Taylor, were you able to hear Mr. McNeely just now?
Yes, ma'am.
And it's your agreement that the order to set aside the order for installment payment should be entered,
Yes,
and that you and Mr. McNeely have reached an informal agreement to resume the payment plan?
yes, ma'am. But the date is on the 15th of every month now, not the 20th. It's on the 15th of every.
15th of the month, beginning this month, Mr. McNeely?
Yes, Judge.
Ms. Taylor, do you understand that because this court is entering the order setting aside the previous payment plan, that there, should you miss a payment, Mr. McNeely's office may immediately resume garnishments?
Yes, ma'am.
Okay. That being the case, Mr. McNeely, the court is signing the order setting aside the previous order for installment payments. The Civil Division will mail copies to the parties at the addresses that appear in the court file. Anything else, Mr. McNeely?
No, Judge, thank you.
Anything else, Ms. Taylor?
Yes, I would like a total of Mr. Christopher, if you have, so I can know this, where I'm at for this date.
We will send you I have it actually in front of me. I prepared for today's hearing. I'll send you a copy so that you can have that. And then when you call my office, to set up payments, we can go through that as well.
Okay,
But
thank you.
You just want the total, I'm sorry, you just want the total due on the judgment, Ms. Taylor?
Yes, ma'am.
What is that, Mr. McNeely?
$4,263.31.
Anything else, Ms. Taylor?
That'll be it.
Thank you so much. You both have a wonderful day.
Thank you,
Okay.
Judge. You too.
Ma'am with the Mickey Mouse shirt on? Oh, still waiting for her. Is it Mayering, Miss Mayering?
Yes, Myring.
Would you like to speak to Miss Adams?
Yeah, that would be fine.
We'll get you into a breakout room with her.
Okay.
Thank you. Good morning, Mr. Morton.
Morning, Your Honor.
How are you, sir?
Just a normal challenging day after the holiday.
I have not seen anyone labeled Louisette this morning, waiting for one person to connect their audio. The policy of this courtroom is 15 minutes after the scheduled start time. You know that, so we'll see if she's here by that time.
Yeah, the only other person I see is the woman that's checked in underneath the Samsung.
I know, that's why I'm waiting for her audio to connect. I'm not sure if that's your defendant or not. And it sounds like you might be in another courtroom.
That is correct, Your Honor. I'll put myself on mute and I'll just
Thank
and I'll
you.
hold.
Okay. Ma'am in the blue collared shirt, your name, please.
Deborah Samuel.
And ma'am, is your case scheduled at 9:45
Yes,
under the last name of Cummings?
yes.
The attorney is here. She's in a breakout room with someone else. After we get that case called, we'll get you matched up with her to discuss your case, okay?
Okay, thank you.
Thank you. This is 191427GC. This is Westlake Services versus Jacqueline Adams. May I have your appearances, please?
Good morning, Your Honor. Abby Meyering on behalf of plaintiff,
Your P number, ma'am?
P81966.
Thank you. And Ms. Adams, if you state your name for the record, please.
You said state my name,
Yes, please.
Jacqueline Adams.
Thank you. Today is the day and time set for hearing on plaintiff's request to set aside the installment payment order. The parties have had an opportunity to speak. How are we proceeding this morning?
Yes, we've agreed to basically resume payments, which really would require a new order. So I don't know if the court has an order, or we can, submit something under the 7-day rule.
Absolutely. What's the new payment plan?
It will be $100 a month, every 2 weeks, beginning January 13th.
Ms. Adams, is that your agreement?
Yes,
Yes, ma'am. You may submit that order pursuant to the 7-day. Anything else in this matter on behalf of the plaintiff?
That's it, Your Honor.
Anything else, Ms. Adams?
no, that's it for me. Thank you.
Thank you.
Thank you.
I'm sorry, before you go, as a procedural matter, then the court will grant your order setting aside the last installment payment order. You just get the new one submitted for the 100 per month starting January 13th, 2023, and bi-weekly thereafter.
Okay.
Thank you.
I do have
Ms.
another.
Adams, you're free to go. I'm sorry. Were you starting to ask something?
I see the defendant is here on my other case.
I was just gonna say, we're gonna get you into a breakout room with her to discuss that case. Ms. Adams, you are free to go, ma'am.
Thank you.
This is 22506 This is Holiday Woods versus Roshana Lewis. May I have your appearance, please?
For the record, Your Honor, Attorney Ian Morton of Pallets Law on behalf of Holiday Woods.
Thank you. Today is the day and time set for hearing on plans request to set aside the dismissal, reinstate case and set for immediate hearing. The court received the motion on December 6, 2022. Notice was sent to the defendant. The defendant has failed to appear. There was no response received to the motion. Mr. Morton, how would you like to proceed?
Your Honor, at this time, we would ask that the dismissal be set aside, and this be held as the hearing on entry of the judgment, but I'll leave it to the court's discretion if they like to do that or not. I also would just before I forget, thank the court for its patience as coming back to the holiday. We've had to juggle our schedule around a little bit, which is why I'm juggling in more than one court than I expected this morning.
Understood, sir, and appreciate it. The court will not take this hearing as for entry of judgment. That's not what was prayed for in your motion, but the court will grant the motion, reinstate the case, setting aside the dismissal. Schedule the matter for hearing. We can put it on our next landlord tenant day, which will be January 11th
Sounds good.
at, let's say 10 a.m. I don't know what else is rolling over. January 11th, 2023 at 10 a.m. on Zoom back here in number 1. Anything else, Mr. Morton?
Nothing else, Your Honor. I appreciate the court's patience, and glad we all made it through the holidays.
Have a good day. I'll see you next week.
Thank you. You too.
Marianne, I know if I say it out loud, what'll happen.
No,
So I'm not gonna say it.
no.
I'm not gonna say it. I'm not gonna say it. I'm just gonna come grab a Post-it note. This is 224718 GC NAR Inc. versus Deborah Cummings. Have your appearances, please.
So Abby Meyering on behalf of plaintiff P 81966.
Ms. Samuel, if you would turn your camera on and identify yourself, please. State your name for the record, ma'am.
I'm Deborah Samuel.
Thank you. Today is the day and time set for the first pretrial in this matter. Ms. Meyering, how are we proceeding?
Yes, we did reach a resolution, consent judgment for 50 a month, beginning January 13, 2023. Would you like us to submit that under the 7-day rule?
Well, Ms. Cummings,
Yes,
were you able to hear the attorney just now?
yes,
And you'd like to enter into a consent judgment where you agree that you owe the $1,539.06
yes,
listed as damages. There's a filing fee of $55. There'll be a service fee attached as well, and the statutory attorney fee. You'll make payments of $50 per month beginning
Yes.
January 13th.
yes,
And ma'am, because you're appearing on Zoom, there's not a signed consent judgment. The attorney is asking if that consent judgment may be submitted 7-day, which means she'll send it over to the court. She'll send a copy to you. If it's what you agreed to, you don't need to do anything, and 7 days after the court receives it, we'll sign it.
yes.
Is that acceptable? Okay. Yes, ma'am. Please submit that consent judgment.
Okay, thank you, Your Honor. Just to clarify, I said January 13th as the start date, right?
Yes, ma'am.
Okay. All right.
Anything
yeah,
else
we'll
on
get-
behalf of the plaintiff?
That is it, Your Honor. Thank you.
Anything else, Ms. Samuel?
No, no, thank you.
Thank you. Ms. Meyering, if you would just let Ms. McKinnon know that I asked after her and hope that all is well.
I'm sorry, what?
I said, if you would just let Ms. McKinnon know that I asked after her and I hope that all is well.
I will. Thank you. I'll do that.
Thank you.
Yep.
Have a good day.
You too.
Mary Ann, we have one left from 9:45. And I think we're close enough. 212017 GC. This is Citibank versus Arthur Parker. This case was scheduled at 9:45. It's now 9:58 by this court's clock. Policy of this courtroom is typically 15 minutes after the scheduled start time. Have not seen an attorney for Citibank or Preston Nate's office. This is the defendant's objection to a tax garnishment. Oh, that's not a good sign. Good morning.
Good morning, Your Honor. Happy New Year.
Happy New Year. Where were you last week?
I took vacation.
I didn't authorize that. I looked up, I was like, who was
I had to sneak out. I don't think any judges would let me go. But I'm back,
I'm on
so
civil case. Good to see you.
they have a
I'm on
Najee,
civil cases this morning.
they have a Najee Goodman scheduled for a tether violation. And it doesn't make sense in the computer, but they had him on the schedule for today. Najee Goodman.
I know who that is. I thought we had him on tomorrow for a new case, Mary Ann. Do you have a case number?
No, ma'am, it's his tether violation.
Okay. Oh, you said it twice and we have him sometime this week, but not today because I only have civil and landlord tenant cases.
Can you send me a text when the next court date is, and I'll make sure he's on the schedule?
I don't know what it is. I'm looking for it right now.
Hi, officer. How are you?
Good morning, Mary Ann. How are you?
I'm
Very
great.
good.
Thank you. Happy New Year.
Happy New Year.
How do you spell his first name?
Najee.
1 second.
Sorry. Marianne, I thought it was tomorrow. I thought he had new stuff on our Wednesday docket for some reason.
Ten o'clock with Judge Oakley today.
Oh. Oh, that's who is doing the bench warrant arraignment.
Sorry, Your Honor.
Why are you running? It's Judge Oakley right now.
Oh, it's today, Judge Oakley?
He's doing the arraignment right now.
Okay, thank you, Your Honor. You and your staff have
Do
a
you need his
wonderful
number?
day.
Do you have it?
I have
You
it.
too. Thank you.
All right, thank you, ma'am.
Bye-bye. Back to 212017 GC. It's now 10:01 by the court's clock. No one has appeared in this matter. And as much as these were defendant's objections and he failed to appear, they will be deemed invalid. The- Marianne, that's our last until 11. We'll stand in recess until that time.
Okay. Sir, can you hear me? Sir, good morning. Sir, can you hear me? Sir, can you hear me?
Yeah, I hear you.
Hi. What is your name, please?
Arthur Parker.
Arthur Parker. We're supposed to be here at 9:45.
Well, I was trying to get this Zoom hooked up, and I'm sorry that I just got it hooked up and everything hooked up. The lady at the clerk at the front really helped me out.
Oh,
She's the one
good.
that got me hooked up.
Okay, hold on one second.
All right, thank you. Oh boy. Mm-mm-mm. Oh, wow. Oh boy. Oh boy. Mm-mm.
Mr. Parker? Mr. Parker? Mr. Parker? This is 212017 GC. This is Citibank versus Arthur Parker. Mr. Parker, state your name for the record, please, sir.
Arthur Lee Parker Jr.
Thank you. Sir, your case was scheduled at 9:45. I called it at 10:01. My secretary advised me at about 10:30 that you had joined our Zoom.
Yes. Yes, I just joined Zoom. I've been trying to get over with the Zoom since 9:30, and I just finally got logged into the Zoom. And so she just logged me in, and the lady at 34th District helped me out too. But she helped me get on the Zoom because I didn't know how to get on the Zoom.
Mr. Parker, would you
Yes,
stop
ma'am.
moving around for a moment? Would you just stop moving around for a moment? The plaintiff's
Oh
attorney
yeah,
did not
well, I
appear
just had
this.
to pick up the sheet. Okay, I'm sitting down now. Thank you.
Thank you. The plaintiff's attorney did not appear this morning. This is your objection to a tax garnishment. Your objection indicates that you have an installment payment order.
I have a what now?
You filed an objection to a tax garnishment.
Yeah.
Your objection indicates that you have an installment payment order.
Well, yes. Well, that was what the problem was, is that we was paying that every month, and my wife we really didn't have the money to pay those bills, so that's why we made it with them to just pay $50 a month, and they was okay with that ever since January. We've been paying that ever since January. And now my wife is back to work, and we just trying to make it right now. We had a bad water leak in our place. We had Roto-Rooter come out and tore up the
Mr. Parker? No. This is an objection to a tax garn, okay? Your objection is that you have an installment payment order.
Yeah, well, that's what I'm talking about, ma'am.
Okay, but Mr. Parker, I looked in the
Yes,
court's
ma'am.
file. I looked in the court's file last week in preparing for today's hearing, and there is not an order for installment payments in the file.
What you mean? But there's no record of us paying them ever since
That's not what I
January.
said.
We have been paying.
That's not what I said. What I said is there is no order for installment payments. For your objections to the tax garnishment to be deemed valid, there are only a few reasons. There are only a few valid legal objections to a tax garnishment. And they're listed at the very top of that form, the objections to garnishment form. The funds are
Yeah.
exempt. There's a bankruptcy. There's an installment payment order. The maximum amount is already being withheld. The judgment has been paid or the writ was not properly issued. You check the box that says that an installment payment order issued on January 24th, 2022 in this file. What I'm saying to you is in reviewing the file, touching every piece of paper in the file, do not see an order for installment payments. If you have a payment agreement with the plaintiff's attorney's office, Stanger and Stanger, that's something separate. There is not an order. There is not something in the court's file which would protect you from a tax garnishment. So my question to you is not if you've been making payments to them, but is there an order for installment payments that you have in this matter?
Well, no, because this is the first court order that we've had. This is a court, order, the first time that we ever had an order on this, because we was going directly with them and they was taking the money out of our bank account. So we was doing it on just talking person to person to make to make sure we pay them back. And that's what we was paying them back. And then after a while, we come up with this letter that they was sending us to court after we had been paying them every month with this $50 a month. So we thought everything was okay until we got this letter of a garnishment. We've been going through terrific times. When my wife got into a car accident, she had been off work for over 2 years. And so we made that, that situation with them, with the $50 a month, that was all we could afford. I was the only one working, and I was even having sickness problems because I have like the gout and I had to take off work a lot. So we just been barely making it. And then they want to try to garnish us when we're already paying them. That's terrible, for us. Now, anyone else that may be working maybe can afford it, but we can't really afford anything else. That's why we did it like we did it, and we thought we were okay. And I'm just sorry that I wasn't at the meeting at 9:45. But this is my first time I ever did this with Zoom, so I didn't know about the Zoom or court cases or punishments or anything like that.
That's fine. That's fine. No worries. You don't have to apologize. But what I'm saying to you is that you have to have a valid legal objection to the tax garnishment. And a voluntary payment plan with the plaintiff's office is not a valid legal objection to a tax garnishment.
Well, I'm trying to do what I'm supposed to do in order not to be getting garnished. If I knew I had to have a court case or whatever, this is my first court case I ever had about this situation. So I didn't know I had to have but me and my wife didn't know we had to have a court
Mr.
case
Parker,
or anything.
No, I understand that. But what I'm saying to you is that in the case, the parties can agree that they won't do any garnishment, but they'll accept these payments. But there's nothing like that in the file. So because there's nothing prohibiting it and tax garnishments are allowable, the court will have to find that your objections to the garnishment are invalid and will have the state release the tax garnishment, the tax funds to the plaintiff's attorney's office.
Well, I hope it doesn't go that way, because we can't afford it. So if we can get some representation from the court stating that they will accept this $50 a month, then that's all but that we really need. That's what we need.
Mr. Parker, the court cannot represent you. That's number one. Number two, unless there's a written order prohibiting them from this tax garnishment, they will receive the funds. The ruling of this court is that your objections are invalid and any funds held by the state of Michigan for the tax refund will be sent to the plaintiff's office.
So how can the court see doing that when we have been paying? If we've been
Mr.
paying,
Parker.
I mean, why do they need to garnish you? I never been garnished for anything ever, and I'm 66 years old. This is my first time I ever been garnished by anyone. Either
Mr.
I went
Parker, I
to
understand
bankruptcy
that.
or whatever.
I understand
know?
that. I appreciate it. And I respect the position that you're in. But what I'm saying to you is that I don't know what would cause a plaintiff's office to
Hey,
file a
excuse
tax
me, that's my
garnishment.
wife. Keep calling. She's at work. Is there any way I can log her in with a three-way? I don't
It's
know how
not
to
gonna
do that with
change,
this phone. I got a.
Mr. Parker, it's not
Is there
gonna
any way I
change the
can do that?
ruling.
And she can get on the call
It's
too.
not gonna change Mr. Parker, it's not gonna change the ruling of the court, and your name is the only name listed in the court file. So I wouldn't let her address the court in this matter.
Right. Yeah, I understand now.
Okay,
So that means that, but that you're gonna accept garnishment for them. That's what the court is going to do.
the court is signing the order that finds your objections to the tax garnishment invalid and directing the state to release your income tax refund to the plaintiff's office. Or not just your refund, any funds that are due to you from the state of Michigan will be released to the plaintiff's office.
Well, that's not really that much. I'm only getting about 200 a year,
Okay,
if I even get that.
that's all that this is about, the tax
Well, how
garnishment.
come they just can't accept the doggone $50 a month? That's what we agreed upon. You know, that's what I'm saying to you, Judge. I mean, they're already getting the $50 a month. They don't need to go in any further. So can't you stop this garnishment stuff and just have them accept the $50?
I can't make them without an order. And that's not what's before the court this morning. There is the objection to the tax garnishment. That is the only thing that's before the court this morning.
Right. Well, can't
And
you
it's not,
overrule that?
I'm not, no, I can't
Oh,
make up
come
new
on,
rules,
Judge.
Mr. Parker. I can't make up
Oh.
new rules. And Mr. Parker, honestly, if you're making your 50 per month, the court suggestion to you would be to continue to make it.
All right. Well, we will. I mean, at
Thank you, sir.
$200 a year, that's not that bad. So I just don't
It'll
want to
just-
have to pay that.
You don't want to have to pay what?
You know, the taxes, the money that we get from the taxes, the state tax.
You don't want them to take the $200?
I mean, we really can't afford it, is what I'm trying to explain to you. I mean, $50, I mean, we'll try to raise it up when we get a little better money situation in our life, which should be recently. But my wife just got a raise and I'm working every day and I haven't retired and I'm not ready to retire right now. As long as I'm healthy and doing what I'm supposed to do. So we gonna pay these people back. We owe them, Judge.
Thank you, Mr. Parker. Have a good day, sir.
So you still gonna take them taxes?
I'm still going to follow the law, Mr. Parker.
So you think that's right to do that? I mean, is it the law that you have to pay, but we've been paying what we owe them back. But they just want extra. We don't have extra.
Mr. Parker, that concludes this matter. You have a good day, okay?
All right. Well, my wife will hate to hear it. Thank you.
Thank you.
Good morning.
Good morning, sir.
Good morning.
Hi. I don't see Mr. Strauss here yet. When he does come, do you need a breakout room with him?
What I was going to ask you is that Mr. Strauss yesterday called me, told me he was going to the hospital. I don't think his health is good. And he asked me if he could submit a proposed stip in order to adjourn. And I said, well, yeah, no problem, I guess.
Oh,
He submitted something on the website yesterday afternoon. I haven't been able to ascertain that or not, so I just logged in.
okay. Okay. Give me 1 second, please.
Thank you. I don't
Yeah.
think he's gonna be logging in this morning. Thank you.
All right. Thank you. Sir, how long of an adjournment do you need?
We're pretty close to settlement, maybe just 30 days, and I think we should have it wrapped up, if that's okay, please.
Okay. All right. I just informed the judge she's going to come out in 2 seconds.
Okay, thank you so much.
Yep. You're welcome.
This is 222032 GC, Synchrony Bank versus Glenn Jackson.
Good morning, Your Honor.
Sir.
I'm sorry, Your Honor. Good morning, David Canine, last name spelled C-A-N-I-E, P61828, appearing on behalf of the plaintiff in this matter.
Thank you, sir. Today was the day and time set for the Zoom bench trial. My secretary has advised me that Mr. Strauss is unavailable this morning.
Your Honor, that is correct. Slightly more nuanced, though. He contacted me yesterday. I don't think his health has been very good over the last year or so. He told me he had to go to the hospital and asked me if I would agree in theory. Obviously, it's up to the court to stip to adjourn, to which I responded, of course. I don't know if he actually submitted the stip in order to adjourn, and I don't anticipate him being on the call or at trial this morning. So, thank you.
Thank you for your candor, sir. And the court usually requires a stip and adjournment, but based on the fact that you've had communication directly with Mr. Strauss, he's unavailable, and I don't hear an objection from you. The court will adjourn today's bench trial to our next civil date, which will be February the 7th, 2023 at 1 p.m. Back with me, back on Zoom, unless we hear anything from the parties, otherwise resolving the case before that. February 7th at 1 p.m. Anything else, sir?
No, just that the parties really appreciate the accommodation. Thank you, Your Honor.
Thank you, sir. Have a good afternoon.
Likewise. Happy New Year. Bye-bye.
Happy New Year. Mary Ann, that is this court's morning docket. We'll stand adjourned until our 1 p.m.
Okay, do you want me to take us down and bring us back up, or what do you want me to do?
Yes,
Okay.
let's come all the way down.